buyers and work in every facet of default servicing that's out there. We work with individual investors on up to large hedge funds and national lenders, as well as terms of performing foreclosures, default servicing work, and really anything in between. So I've got a pretty diverse knowledge, a lot of different areas, and work creatively sometimes to try to find solutions to problems. So I'm glad to be here tonight.
Wonderful. So we did run a poll to see what everyone's questions were about, and obviously the biggest things are the stages of foreclosure process, the key stages. Let's not go through the entire court system, but what are the key stages from beginning to end that would go to for each one of us? Harris, what is in Florida? What are the key points, and what is typical foreclosure cost and timeline?
I'm sorry, I'm having a very hard time hearing David. I can hear the other. I think you said that the question's directed to me, but I can't really hear that well.
Harris, can you feel maybe try calling in with a phone number in? I can give you a phone number for the email.
I'm sorry, I can't hear you.
There may be a way to do it through audio. So I'm going to go over a little bit sum up. And I'll get information. Now, can you share a little about the Ohio process? What our cost and timeline?
Yeah, the Ohio foreclosure process, again, is going to be dictated typically by your loan documents. In most situations, you have to send a notice of default letter that basically set forth certain rights that are in the mortgage itself. Once that's been sent and 30 days have been expired, then you're in a position where you can proceed with your foreclosure complaint. Under Ohio law, we are required to essentially obtain a title search and obtain what we call a preliminary judicial title report. It basically certifies the accuracy of the title. Once that's done, we prepare the complaint. We get everybody served. They have 28 days to answer. And then whether the primary defendants have answered or not depends on the next step. If they have not answered, then we can proceed with a default judgment, a motion for default judgment. We also have, if they have answered, then we would file a motion for summary judgment. Once we obtain the actual judgment, be it default or summary, then we're in a position where we have to file an order of sale. That's when the sheriff is directed to actually advertise, appraise, and sell the property, get set for sale, and then once the property sells, the next stage is the confirmation stage, where an entry gets filed with the court approving the sale and approving the distribution of the funds. And then shortly thereafter, once the funds are paid in to the sheriff, there will be a deed that will issue out there. So in general terms, that's the process.
What other states are you licensed in, Tom?
I'm licensed in Michigan and Kentucky. You want those states too?
Just very quickly, yes.
Yeah, the Kentucky process is essentially very similar to the Ohio process. There are some slight changes, but essentially it's the same thing. Michigan is different in the sense that it is a non-judicial state. So you can essentially foreclose on a property, really can't get a money judgment if that's what you're looking for. But if you're looking for just foreclosure, that can be accomplished in a very short period of time. The only problem you have in Michigan is, even though you get a foreclosure done in 3 to 4 months, maybe even shorter than that, is you have a longer redemption period out there, which is 6 months. So those are the other states, kind of in a nutshell.
How often do they come back for redemption? How often do they come back for redemption? Question real quick.
I didn't hear the question.
How often do they come back for redemption?
How often do they come back for redemption?
Oh, I don't think that I have ever seen someone attempt to redeem.
One of the questions in chat was real quick. Can you get a homeowner to sign off on the redemption period?
Well, actually, during the redemption period, it just depends where you're at. Yeah, you could probably get a waiver. That's going to be more of a title issue. Most title agencies, in my experience, are willing to close within the redemption period because the risk is generally so low.
I can add something about that in Florida. I am a title agent, and down here, I think it's the opposite, actually. I don't believe that most underwriters would close during the redemption period.
You're saying you would close?
Would not.
Would not, okay. Yeah, we don't typically have that problem here in Ohio. Most will, and in the other states too.
All right. Awesome. So I know, Harris, your video is not going to show up because you're not going through the computer, but that's fine. I can actually ping you on. I'm going to now bring in, bring it up. Mr. Kelly. Matt, can you give just synopsis of the states you kind of invest in and what timelines you look for, since you're not an attorney, but you can kind of give a basis?
Please know when I say I'm not an attorney, I manage a considerable amount of them and know just as much, if not more, than quite a few attorneys. But states in which we operate are referenced as non-judicial foreclosure states, which means that our primary goal is to stay out of court. The timelines are traditionally very short, from anywhere from approximately 60 days to a little over 120 days. The basic phases of non-judicial foreclosure is notice of default, notice of sale, trustee sale. That's summarized as you're in default. If you don't do something, your property is going to go to sale. Your property is going to go to sale, and then it actually goes to sale. It's a very simple process that can get a little bit complicated, but once again, the better informed and educated one happens to be, the cheaper and easier it goes.
Awesome. Thank you very much. I'm going to go back to the poll, and one of the other questions it seemed to be very heavily interested is the state of. How much concern is there when you're foreclosing on a property when there's an estate or a passing or probate situation? Matt, I'll let you take off first.
On our end, it's absolutely none. It has zero relevance, whether it's in the estate of, somebody's deceased, if it's traditionally in regards to noticing requirements, as if it's in probate, there should be documents recorded as to the additional individuals that may be required to be noticed, but it does not delay, forbear, or hinder the foreclosure process in any way, shape, or form.
Awesome. Harris, what's your experience with dealing with estate issues?
Yeah, so we see them all the time, unfortunately. It does not really delay anything, but it does add another layer of people that need to get notice within the litigation.
Oh,
So
Harris, we're losing your audio.
Excuse me?
Oh, we lost your audio for a second.
Are you back now?
Yes.
Yep. So the borrower's heirs need to get notice of the lawsuit and have an opportunity to respond to the lawsuit. Depending on how the borrower held title to the property, if the warranty deed transferring title to the borrower created some rights of survivorship, then it transfers automatically to the other party on the deed. Absent that language on the deed, we would need to get some research to find out who the heirs of the borrowers are that now own that property and have an interest in the property, and for our purposes need to get foreclosed out. Oftentimes we don't have that information, and we have to have a guardian ad litem appointed to do some research to find those people and let us know how their interests can be protected. So it may be a little bit more expensive because we have to appoint a guardian ad litem, anywhere from $200 to $700 for that guardian. And it does cause another 30 or 60-day delay in terms of the foreclosure process.
Great. I'm going to go back to the poll again. Go right ahead. The question, if it's in probate, just the executor needs to be notified?
In Florida, yes. That would be actually a very good scenario. The best case scenario is that there's another party on the deed and right of survivorship language on the deed. The next best scenario is that there is an actual probate estate open and a personal representative, is what they're called in Florida, or an executor, as you may know it, is appointed. In that case, we would certainly speed up the process and have all of the appropriate information in order to notify the heirs of the borrower, likely without appointing a guardian ad litem.
All right. Great. Back to additional questions, which were on the poll. Give me 1 second. When you're doing a deed in lieu, what's your, from an attorney point of view, and I'm going to bring in Matt as well, putting a deed in lieu inside of a modification, or can we still file a deed in lieu and still foreclose on a property? I'm going to let Matt start off with that. Let me just get Matt unmuted. Okay. Matt, what's your feeling about doing those kind of things?
Those are a lot of different questions. So doing the first one, can you do a deed in lieu with foreclosure? You can initiate the process, but completing the deed in lieu would negate the existing foreclosure with very few exceptions. And I'll mention those in just a second. But with the deed in lieu, it's traditionally where the homeowner signs the property over to stop the foreclosure process. In doing so, there's an estoppel affidavit signed, there's a grant deed, and the actual deed in lieu of foreclosure. It is something that I highly recommend if you're not well versed with it or have been involved with this several times before. Have an attorney, title company, somebody handle the process for you. It's very inexpensive and it's very, very easy. But doing a deed in lieu inside of a modification, I don't know how that would be legal or how that would take place, quite honestly, as a deed in lieu is, again, signing the property over to the beneficiary without contingencies or anything else along those lines. Was there any other questions involved with that one, Dave?
No, just a deed in lieu inside modification.
And real quick, how to do the foreclosure and the deed in lieu at the same time. That's called putting anti-merger language within the deed in lieu, and that's traditionally done so that title may be cleared at a later point in time in the event there's additional defects on character or defects on title, which separate the actual modification or the actual obligation from the property, so that once again title may be cleared at a later point in time when and if needed.
Awesome. Tom, from your point of view, same questions. We've talked about this before, putting deed in lieu inside modification agreement and filing deed in lieu and still foreclosing from Ohio, Michigan, Kentucky.
Yeah, I agree with Matt in the sense that I don't know how you can do a deed in lieu as part of a modification agreement, because I don't, I mean, there are two different things. A modification is essentially attempting to reinstate the note, whereas a deed in lieu is the total surrender of the property. So they're sort of inconsistent in terms of doing that. If the concept is that what we're trying to do is say we're going to modify, but if you default on the modification, then we get to take a deed in lieu. Those things get to be pretty aggressive out there, and that's something that I think you'd want to evaluate on a case-by-case basis in terms of what your downside risk is. As far as the deed in lieu process, I mean, Matt's really summed it up pretty well, I think, in the sense that I think the merger language is really key because in Ohio, under Ohio law, that if you own a mortgage interest and then acquire a fee interest, basically a greater interest, you lose your right in the mortgage. The mortgage is extinguished unless you put specific language in the modification agreement, and we do it in our deeds as well, that say there is no intent to merge, because that's what keeps your lien position in place. It allows you to essentially acquire an interest in the property, do the deed in lieu. Maybe you're a junior position, or you're a senior position and there's a junior mortgage. You don't want to pay them off right away. You can wait, make the property productive, do what you want, let that second mortgage sit there, and maybe they go away entirely. Maybe at some point you do what is oftentimes referred to as a friendly foreclosure, where you're just basically foreclosing to get rid of those junior liens.
Right. All right, Harris, what's your point of view on those two topics?
Yeah, I think Matt and Tom gave a good explanation. I think one thing I'd like to add from a little bit of a broader perspective is the goal from a deed in lieu and generally a mortgage foreclosure case is to get marketable title to the subject property. You can get a deed from whomever the owners are, whether it's the borrower or some third party, maybe condo association or other party that somehow became entitled. The question is whether that deed conveys marketable title. Marketable title means you have the ability to go sell that same property tomorrow without having to do anything else, satisfy any other encumbrances. Whether or not the deed conveys marketable title is an important issue. If it does convey marketable title, you're the owner and your mortgage essentially becomes meaningless because you would have clear title. If there are other encumbrances besides the parties that you're getting the deed from, whether that be the borrower or someone else, you need to keep your mortgage alive so that you can foreclose those other interests out, which is why the language that Matt and Tom referenced about non-merger is right on point, in my opinion. The most important language, or very important language that's included, it should be included in the deed. And one other thing I'd like to add is that while you may need to eliminate other liens, that leads me to say you should never satisfy your mortgage until you're absolutely ready to go sell that property. Because in the event there is another lien out there that you need to foreclose, you lose that ability once your mortgage is either merged into the deed or satisfied. So I always recommend not to record a satisfaction of the mortgage until and unless you absolutely have to, which generally is at the closing table when you're going to sell the property.
Tom, do you have any advice about that as well? It's a great point that Harris is bringing up.
Yeah, no, I think that's very valid. I think you just want to keep, your mortgage is on the property. Don't go and release them knowing that you have control to release those mortgages at any point in time, because you just never know what's going to crop up, or maybe you're going to want to take a different direction with the property than you thought. So you leave your options open until you absolutely decided the direction you want to go. And I would agree with Harris totally.
Awesome. Thank you. You're not double closing. You're just not officially filing the closure. Harris, I know this is a big thing in Florida, safe harbor. Can you just give a quick kind of overlay of what safe harbor is and what the importance of safe harbor is?
Yes, absolutely. Safe harbor is a very big topic in Florida foreclosures. Becomes a very contested issue that we deal with almost daily. Safe harbor is a Florida statute that controls when there's an association that the property is a part of, whether that be a condo association or a homeowners association. And basically, this Florida statute says that if the association was properly joined in the foreclosure lawsuit and served with the foreclosure lawsuit, generally speaking, they must abide by the Florida statute, which says the lender that forecloses and takes title only owes the association the lesser of 12 months maintenance or 1% of the mortgage. The safe harbor statute does not apply to third-party purchasers at foreclosure auction. or someone that's not a direct assignee of the original lender of the first mortgage. So the fees that you save if the association honors the safe harbor could be enormous. Oftentimes, we're dealing with loans with the default date of 08, 9, 10, and the same way the mortgage wasn't paid, oftentimes the association wasn't paid. So you can factor in maintenance from the past 8, 10 years, which is what the association oftentimes believes they're owed. But the legislature in Florida enacted the statute which greatly reduces the amount that the associations are able to collect. Now, oftentimes the associations don't honor the safe harbor, unfortunately, and it's certainly an issue of back and forth negotiating and unfortunately sometimes litigation. So each association and their management company deal with interpreting that statute differently, but we certainly do our best and have had a lot of success enforcing the safe harbor statute against the various associations throughout the state of Florida.
Harris, and I know that when you're going through a foreclosure and it's not going well, or it's going well, but you didn't secure safe harbor, typically you'll actually start the foreclosure over to make sure safe harbor is taken care of.
I'm not sure I understand the question when you say not going well in foreclosure.
If it's going well, but the fact that safe harbor wasn't taken care of, would you stop the foreclosure and back up to ensure safe harbor is filed correctly and all the paperwork?
Yeah, so that definitely becomes a business decision on behalf of whoever owns the loan at that time. If the borrower is not contesting and the only issue is the association and their ability to abide by the safe harbor statute, then I certainly would consider starting over. And that's a case-by-case basis. It becomes a business decision. If you believe you may be able to negotiate a reasonable settlement with the association, then it may not be necessary to start your foreclosure action over.
Kathy in the chat asked, can you clarify, if I buy a non-performing note from a hedge fund, am I covered under safe harbor?
As long as there's a direct link from the first mortgage, from the original lender of the first mortgage to whoever the eventual party that owns the loan, then yes, you should be protected. Okay.
And then the last one is, if HOAs fight a safe harbor, what's the percentage of win-losses? If an HOA loses, then are they paying the lender's costs? How does that work?
Well, are they paying on what?
If the HOA, how often does the HOA fight and win?
Well, win is an arbitrary term. I mean, how often do they get every penny that they're asking for? It's probably unlikely. More often than not, there's going to be some reasonable settlement that the parties are going to reach. So if the safe harbor says that the association may be due $1,000, for example, and the association believes they're owed $10,000, rather than engage in protracted and expensive litigation, oftentimes the parties may settle for $2,000 or $2,500. So defined win is somewhat arbitrary, like I said. There's a black letter of the law, and then there's business decisions that need to be made as a result of people's interpretation of the law. And unfortunately, the association and their lawyers often interpret the statute differently than the plaintiff and lender lawyers.
Wonderful.
So
awesome.
I hope that answers the question.
So I'm going to jump in. I know Matt is muted for where he's at. Matt, do you have anything to add to that?
Certainly. The safe harbor doesn't exist in all states. In the Western United States and quite a few other ones as well, there really is no such thing as safe harbor. What I mean by that is that it's in statute very clearly cited that once the new owner acquires title via perhaps a foreclosure sale, any HOA dues or anything else are completely wiped out. It's considered a subordinate lien. There's a few states where the HOA dues are to be considered a super lien state, and they take priority even over a first mortgage, similar to that of taxes. And I don't want to negate that. But HOAs are something to consider, but in a non-judicial environment, the HOAs, if they have a lien that's recorded, would be notified of the foreclosure action, and after that, they're out of luck.
Awesome. Tom, none of your states deal with a safe harbor, do they?
No, they don't. I mean, condo associations or associations in general have an obligation to file a lien, generally a subordinate lien, and the lien gets wiped out like any other lien. Usually, there's never enough money to reach them, so that typically isn't an issue for us.
Wonderful. Thank you, guys. So I wanted to move on. This is more for states in the Midwest. Talking about contract for deeds or land contracts. Briefly talk about them, what the benefit is, what the attraction is to them, and what worries we have. I'm going to ask this question for those who don't know. Are state-specific laws differ in every state? Tom? Or Matt, do you want to jump in there first? Are you familiar with contract for deeds?
I'm very familiar with contract for deeds. Please note that as a secured lender, I do not engage in contract for deeds. It's exceptionally rare. Purchasing contract for deeds and land contracts, the laws do vary by state. They are not legal in all states, and that's in regards to something called unencumbered title. In regards to contract for deeds and land contracts, the underwriting is questionable, the compliance is questionable, which is why I'm personally not a huge fan of them. I like buying institutional paper, but there is all different types, just it's priced differently. It's been said there's no bad notes or deeds, there's just bad prices. But in regards to contracts and land contracts, the advantages are they can be easier to collect upon in terms of acquiring title. As you're essentially just evicting the homeowner, but there's a lot more to it in that it usually involves an attorney. There are sometimes, like in the state of California, you still need to foreclose on the homeowner. So the cost savings and timelines traditionally are a little bit shorter and cost savings is a little bit more. But in most non-judicial states, the costs average around $2,500 or a little bit up for the entirety of the foreclosure process. Sometimes a little bit more. So that's kind of negligible.
Okay. Tom, I know you're familiar with them as well. Can you jump in here and add a little bit as well?
Yeah. Under Ohio law, what a land contract does is essentially the legal title to the property remains in the actual physical owner of the property, and the person who's buying it acquires equitable title, which is a significant enough title to get you an insurable interest, and it's a greater title interest than just being a tenant or a lessee. And what happens is it's really a seller financing mechanism that the seller gets to retain title. And it potentially avoids having to foreclose. Essentially, under Ohio law, and it's again statutory, if you have a land contract or contract for deed that has defaulted, if the debtor has and the land contract has not run for more than 5 years, you can do a forfeiture proceeding, which is essentially akin to an eviction. It's very quick. But if you acquire a 20% equity position in the property, or the land installment contract has run for more than 5 years, then the law requires that you go to a foreclosure situation, which again is going to tie things up a lot in terms of timing. So typically, when we assist people in drafting these, we caution them about acquiring large equity positions and going for long periods of time. There are typically short-term mechanisms allowing people who maybe have a credit blip that need a year or so to get their credit back to where they could refinance on their own and get out from underneath it. The one concern I would have, and I don't profess to be an expert at all, there have been some questions that have been raised about whether or not land installment contracts are subject to the SAFE Act, and whether or not you really have to, whether or not it's legal for an owner to do that. I mean, if I'm the owner of my own home and it's my personal residence, that's probably not an issue. But as a real estate investor, if I am routinely using land contracts as a mechanism to sort of seller finance my properties, there may be potential SAFE Act violations out there. You hear people say, well, if you do, 3 or less or 5 or less in a year, then it's, you should be okay. To my knowledge, there is no safe harbor under the SAFE Act for land contracts in terms of quantity. So a lot of that is just somebody's, risk level as to where they think people leave them alone. So, I think land installment contracts typically have their place as a short-term mechanism. I don't recommend them as, something that should go for extended periods of time.
One of the questions in chat, guys, is what's a typical time frame for our forfeiture of CFDs? What time period are we looking at for forfeiting the rights of it?
So you're saying if you're in a forfeiture situation, how long would that take to get title back?
Correct.
Probably 45 to 60 days tops.
Wonderful. The next question I want to get into is to be more of a question regarding what's going on recently for more common note investors here. Are questions regarding the do's and don'ts of borrower contact. Recent I won't get too much into it because of the legality of it. There was a comment stated that what can we do as investors about talking to borrowers and our rights about doing that?
I guess I'll take the first crack at it. This is Harris Howard. I think it's something that should be always contemplated, and owners of the loan should tread very carefully when contacting borrowers. Most importantly, you need to know if the borrower is represented by counsel. If they are represented by counsel, all correspondence goes through that counsel. If they're not represented by counsel, I still think you need to tread carefully. Florida has not only the federal FDCPA statutes, but also the Florida.
Harris, we're having a little hard time hearing you. Just if you could speak a little closer to the mic.
Sure, I apologize. I guess I'll go backwards. I think it's important to note if the borrower is represented by counsel. If they are represented by counsel, all correspondence should go through the counsel, not directly to the borrower. If they are not represented by counsel, I still think you should tread carefully in communicating with the borrower. There's all kinds of not only federal regulations, but also Florida has the Florida Consumer Collection Practices Act, which has regulations protecting borrowers from being solicited by debt collectors. So there's a lot of statutes out there that could get you into trouble, and there's too many factual scenarios to go into to say what would be a violation of those statutes. But generally, you should brush up and make sure that you're acting within the guidelines and outlines.
Okay, you're a little muffled still, but I'm going to switch off and let Tom take a crack at it as well. Tom, what's your opinion? I'm not sure if you've seen a new law that passed that came down yesterday, and it basically spoke about how Supreme Court secondary markets not subject to the FDCPA regulations?
Yeah, I've taken a quick glance at it. I haven't read the actual opinion. I think that to some extent, you had a situation where you had debtors that were really trying to further extend the Fair Debt Collection Practices Act in a manner that I don't think it was ever intended. I mean, to make an argument, which that case does, is to say that because the secondary market buyer bought a debt that was once owned by somebody else, that they're collecting a debt for another, to me is a good stretch. And I think the Supreme Court decision was a good decision in not expanding the Fair Debt Collection Practices Act to that. And, you know, because I think that the Fair Debt Collection Practices Act has been overused by debtors as a club for creditors. And creditors or courts in the main, the circuit courts typically are getting pretty frustrated with the amount of litigation. So, you know, that's sort of my commentary on the case. I mean, I think it's important, though, whenever anybody is contacting a debtor that, you know, that they typically, I recommend to my clients, just out of an absolute abundance of caution, that they typically file the guidelines under the Fair Debt Collection Practices Act. You know, the law is clear that if you know, give the Fair Debt Collection Practices Act notice and the person's not covered by the Fair Debt Act, you haven't obligated yourself to comply with it. So, you know, I'm a pretty cautious guy when it comes to this sort of stuff. And, you know, I always recommend that, you know, when you're contacting clients, you let them know you're collecting a debt, what you're doing, you're upfront with them, you treat them with common courtesy. You don't, you know, beat them over the head, call them late at night, call them, you know, early in the morning. You kind of follow the guidelines, and you'll stay, you know, you won't have issues, or you won't create potential issues for yourself that debtors can bring up as ridiculous offenses that are going to cause you to spend money that you don't have to. Again, that's kind of my take on it. I take it conservatively, and again, I talk with clients and we talk through issues on a case-by-case basis.
Thank you, Tom. Matt, can you jump in now and tell us your point of view, maybe of the article or of general knowledge of our ability to speak to borrowers, the do's and don'ts?
Quite a bit. First and foremost, we're referencing secured debt. As secured creditors, what that means is we have rights and remedies far beyond just sending letters and listening to the homeowner's problems a little bit more than the last person that owned this note. As a secured creditor with exhaustive rights and remedies available, you have the ability and the right to put the weight of the law behind you. And that's as to the protections afforded within the secured documents, whether it be a deed of trust or a mortgage. In regards to speaking to the homeowners, Lewis Carroll said it best: do as you say as you do, mean what you say, and say what you mean. These are very, very basic concepts. I don't bluff whenever I'm talking to homeowners. As a foreclosure trustee, when a homeowner calls in, we let them know, in the event they want to, the rights that are afforded to them, and any workout that may be possible is at the lender's good graces, and they are directed to the lender for an alternative other than bringing the loan current in full and paying the loan off in full. In regards to the actual recent decision that took place, quite honestly, I don't think a terrible amount changed, because there's always been very loose interpretations in regards to saying you owe me money, but there's a profound impact upon others saying that you owe someone else money. And this is, servicers are still considered servicers when especially they're collecting on behalf of someone else. But in regards to contacting a homeowner, certainly it's possible. But personally, as one that holds a considerable amount of mortgages nationwide, when I'm in a state where I'm not 100% familiar with various aspects or parts of the collection process, I traditionally leave it up to the attorneys, or I contact them to let them know in advance what I plan on doing as to whether or not that'll cause more headaches for them later on down the line.
Wonderful. I'm going to go ahead very quickly and share what we're talking about that's online. Give me 1 second.
I can quote it if you need, Dave, but I emailed you a copy of the decision.
Wonderful.
The actual decision, not just the news article.
Great. Thank you so much. I'll definitely forward it over to everyone else. So I'm going to go back to opening it up for questions. There's a chat box for everyone to get on the screen. Bring up some chat questions. You know, again, everyone involved here has a specialty, has experience, been around the block a few times, and can answer a lot of these questions. So I did have one question locally that was brought up, and I'm going to bring it up first. We had a private mortgage was held by a mortgage was held by a private individual. That mortgage has been since paid off, but not released. Is there a way, a mechanism to force them to release the mortgage or to remove that lien if they're not doing it already? Harris, I'll let you start off. Go ahead and start first. What's your opinion on that?
Sure. Yep. Florida has a statute that requires a lender to record the satisfaction. I think it's within 60 days of being paid off, 30 or 60 days. And there's a provision that says if the lender doesn't record that satisfaction, you can file a lawsuit forcing them to do so. Depending on the size of the lender, it's surprising that they haven't recorded the satisfaction. But nonetheless, in Florida at least, there is a statute on point that can allow you to enforce their violation of the statute by not recording the satisfaction.
Awesome. Tom, from your point of view, anything to add?
Yeah, I mean, Ohio's a little different. They have a similar statute that Harris was referencing, but it in Ohio statute, it's only like a $250 penalty, so it doesn't have much teeth. Couple things that we look at. Ohio does have a statute that says basically if a mortgage has been on the books, there's a 21-year measuring period. It's either going to be from the date of the mortgage, or if the mortgage specifies a due date when the note was to be paid in full, then it would be 21 years from the date of that due date. It's released by operation of law, so either 21 days from the date of the 21 years from the date of the mortgage, or 21 years from the date that it was supposed to be paid off. It's automatically released by law. That works in some cases, and in other cases, sometimes you just can't find people or whatever. Then you're pretty much stuck with filing a quiet title action.
All right, I'm gonna jump in. Matt, anything you can add to that as well?
Quiet title action, but also you can just have the insurance company insure over the lien. And that's the issue with title policy, showing free and clear title regardless of whatever prior encumbrance is there. Because we're talking about some liens that may be in existence from the 1980s or before. These things are out there, bodies float to the surface once we start digging deep into title. But what you're referencing is just a lender that is able to issue a zero demand, but for some odd reason, according to the general index, that lien was not actually released. And quiet title action, or just contact the insurance company and see what they need to insure over it.
Okay.
I'd like to jump in a little bit on the aspect of the title company insuring over. As a title agent, I would be somewhat hesitant to just insure over. There needs to be a lot more information provided to me as a title agent than me providing to the underwriter before I can get authority to just insure over a mortgage. Granted, if you provide some proof that you actually have wired money to a lender, they've acknowledged receipt of the lender, maybe there's been some correspondence to that effect showing that the loan's been paid off, but just the actual satisfaction hasn't been recorded, and it's a really old loan, I think in that case you probably have a lot of success getting the insurance issued, but anything short of that is going to be not as simple as simply insuring over. There's a lot of risk that's associated with these old mortgages that are lingering around, and title agents and underwriters don't like to have claims filed. So it is a possibility, but there's additional work that goes into that.
Great. There was another question regarding bankruptcy, which is a big thing in our space. Of how often, how many times a year can a borrower file bankruptcy?
I guess I'll take a first crack. I believe it's 180 days after the court order. And each district in Florida has sort of different default rules. I think in the Southern District of Florida, the 180-day time period is the default. And I think in the middle and upper district of Florida, you have to request that language to be input into the court orders. Does that answer that question?
I'm going to go ahead and let Tom for that review.
Yeah, and again, I don't have the code in front of me. I'd want to look at it, but my recollection is that there are threshold times, and basically, if you have serial filers, and it's defined as the specific time frames, and I think your 180-day time frame is right. But if people file so many bankruptcies in a short period of time, there is basically a provision in the bankruptcy code that doesn't allow the automatic stay to attach to the property. And again, there are some hoops that have to be jumped through, and it has to be a true serial filing under the statute. So again, it's just a matter of looking at each case factually and then comparing it to the timeframes in the statute. But if you do have a serial filer who, files, pro se, then dismisses the action, and then, files again, so you never can get your property to sale, or every time it's the eve of sale, they're filing, there is a mechanism out there to stop that from happening. But unfortunately, it probably takes longer than most of us would want it to.
Matt, do you have anything you want to add to that?
It's 3 times a year. After that, it no longer affects the property. In the event what Tom was talking about, where they grant 1% beneficial interest elsewhere, where one spouse files but the other doesn't, that is where the serial filing takes place, or abuse of the process happens, and in rem relief is obtained and recorded in relation to the property, where no foreclosure filed by anybody, no bankruptcy filed by anybody will affect the property for a period of 2 years. Once again, there's exhaustive legal remedies and rights afforded to secured creditors within these scenarios.
I see Tom's head shaking. Tom, do you have a different opinion?
Well, I don't know that I have a different of opinion. I don't, I've been involved in a couple of these, and again, the bankruptcy law is going to be pretty much uniform throughout the United States. I mean, my only issue is from a very simplistic view, I don't disagree with that. But there are different ways to get around the bankruptcy issues. And to deal with it, and if somebody's smart, they can deal with the timing aspects of it. One other thing I might just add here that I think is relevant, maybe not quite on this topic, but what you'll see sometimes that debtors do is they will file what's euphemistically referred to as a Chapter 20. Essentially, what they'll do is they'll turn around, file a Chapter 7, get rid of a bunch of their secured debt, get their discharge, then turn right around and file a Chapter 13 so they can structure the mortgage arrearage basically over a period of time. And that's what gets frustrating to a lot of creditors is, that now they got, they just went through a 7, now they're stuck in a 13 and potentially have a 5-year period of time. So, although we as creditors have a lot of rights that are afforded to us, just because they're there doesn't always mean we don't have to jump through a lot of hoops and spend a lot of money to essentially, and enforce those rights.
Great. Kathy had a question regarding, so what happens if they file and are dismissed for some reason? Can they just keep refiling in Florida?
Like I said, I think it depends on the specific jurisdiction that you're in. I think in the Southern District, they would not be able to file for 180 days, if I'm not mistaken. And I think in the Middle and Northern Districts, you'd have to ask the court to enter that specific language into the order dismissing the bankruptcy case. And I think like Matt said, that simply refiling several times, eventually the subsequent filings, they just don't come with an automatic stay. You can still proceed with your foreclosure action, and there wouldn't be a bankruptcy stay imposed. The debtor would probably file a request with the bankruptcy court to actually impose a stay, but you would have the ability to object to that the more times that the debtor filed bankruptcy. And another thing I'd like to add is once someone becomes classified as a serial filer, you can actually seek prospective relief from the bankruptcy court, meaning you're asking the court to say that they filed 3, 4, 5 times and we're having a hard time getting title to our foreclosure or able to move our foreclosure action. And bankruptcy court, please enter an order saying that regardless of any future filings, there's relief from the automatic stay and we can go and seek in rem relief and enforce our mortgage. So that's something that's recommended and pretty aggressive, but is a good tool to have.
Great. Some of the private messages I'm getting are fearful of the fact you can't foreclose in a matter of if they file a 13. I want to make sure everyone knows that when you're filing bankruptcy, it's a good thing in our world because we're guaranteed payments. We're going to receive payments during the whole process. And if it doesn't, if payments are not received, either we can file a motion for relief or the trustee will file a motion for relief. So a 13 is not a bad thing in our world because actually in our world, it's actually a good thing. We can deal with an attorney and not a borrower. So I'm going to go ahead. I'm going to ask Matt, what is, for everyone here, and feel free again to ask questions in the chat. Matt, what would you say the biggest mistake that most note investors are doing nowadays that are newer in the space that is they're not aware of?
Quickly summarized, I'd say they trust the person selling them the note too much. We put exhaustive amounts of research into vetting homeowners, but I do want to stress approximate equal amounts of effort should also be putting into the seller of the note as to their reputation, the type of notes that they sell, the transparency involved, and to ensure that one receives exactly what one is understanding that you're getting. Looking at title to understand what prior actions have taken place, whether that be any prior foreclosure actions. You may not be the first person to own the note, but you may be the first person to do something about it.
Okay. Awesome. Tom, go ahead and what's your opinion about what mistakes the typical note investors make that are newer, not experienced, or even the experienced ones?
Yeah, I would tend to agree with Matt here. I think that it's basically comes down to the initial due diligence in terms of researching the purchase of the note. I think people get too excited about buying a note, buying $100,000 note for, $5,000. That sounds enticing. But there's a big backstory, in terms of what's going on with that property. What does the title look like? What's the condition of the property? Are there code violations out there? I think code violations are becoming a big issue that needs to be a part of everybody's due diligence process because we're seeing here in Ohio more and more demo orders being put on properties. Where you get investors who buy the note, didn't do the research, and the first thing they're faced with is that $5,000 they just spent on that $100,000 note. That property is going to be demoed. That house is going to be demoed, and usually it's kind of hard to reverse those once they get into the process. So and I also agree is that a lot of these note sellers try to lull you into buying their notes with promises that, that the borrower is going to, or, that the borrower's set to begin resuming payments and doing these sorts of things. You can't bank on those things. I think a lot of that is sales tactic. And again, I think you need to be 100% comfortable with what you're doing. I'll give you an example. We had one here with a client just very recently where I did a title search on the property, found a second mortgage that nobody claimed existed. And the note seller fought with my client and said, there's no lien on there. And finally, they went and did their own search. They found the lien. And, it could have been a disaster for my client if they had not done that due diligence work. So spend the time and effort and the money up front because it'll save you a ton on the backside.
Great. I'm going to go ahead and let Harris speak, and then I'm going to
I think
these questions. So,
thank you. I think Tom's last point about spending a little bit of money up front doing your diligence is a great investment for any new note buyer or any sophisticated and experienced note buyer. A tremendous amount of information can be learned pre-purchase, which can save you a ton of money down the road. And oftentimes the best deal is the deal that you passed up, so you don't go and lose money or walk into a huge mess. For example, maybe an association wasn't joined in a suit. Maybe a borrower is highly contesting a case with a very well-known defense counsel, and there's a chance that the case has to be dismissed. You could be on the hook for a prevailing party's attorney's fees. Some of these things can be avoided by simply doing an exhaustive amount of due diligence before purchase. And I think the other thing to be mindful of is really understanding what you're buying. A note and a mortgage priority should be considered. Are you getting a first mortgage, a second mortgage? Is the original collateral around? Does the seller actually have it in their possession? Does the trustee have it? Has it been filed with the court in a prior case? All of these things can be learned by doing a little bit of investigation before purchase and during your diligence period. And I think, like Tom mentioned, spending some money and hiring an attorney to review your files before purchase is a great investment, in my opinion.
One of the questions that Kathy asks is, how can you ensure yourself and protect yourself from a seller? My response is reviewing the collateral and reviewing the contract, but also looking back at the company who's selling it. Are they new? Are they old? Have they been around for a while? But typically the collateral, the contract, the PSA, typically will secure you. Do you have a different opinion? Harris, let you go ahead and start off with that. How do you protect yourself when buying from a seller and ensuring you're getting what you're buying?
So a couple things. I think diligence is a really important factor. Looking through what they are representing in the contract versus what they're sending you copies of. And I think the actual contract, the contract is only as good as the two parties that are to that contract. If the seller's been in business for a long time, and they have a reputable name, you can probably rely on that contract a little bit more. If they're not, it's the first time you're doing business with them, the representations that they're making in that contract may not be as meaningful. And unfortunately, if you have to sue them over that contract, you may not be able to collect upon that lawsuit because they may be a fly-by-night entity. So doing business with good, solid companies that have been around for a while, talking to other people in the industry about who they're buying notes from and what they were able to get from them and whether they delivered on the bargain that was made between the two parties, I think are really important. But just doing some research up front, not only in the collateral and the loan that you're buying, but like the other gentleman said, in the seller that you're dealing with.
Awesome. Tom, do you have anything you want to add to that at all?
No, I think, just generally, it's the due diligence process. And if there's red flags, if you're getting pressured to move very, very quickly on something and they don't want to give you an opportunity to do due diligence, I think that's a red flag. I think, good note purchase contracts should have a buyback provision, or that they'll buy the note back if there are defects found, for at least a certain period of time. Those are things you want to look for. That I think that the seller's being upfront with you. The other thing that's really important too is to make sure that you get a chance to look at the collateral documents. I mean, you want to see that there's all the assignments there on the mortgage, that there is a chain. It goes from A to B to C to D. And that they have all the allonges to the note as well, or the assignments of the note. Too many times we find problems in that area, and it can delay the foreclosure process significantly, increase holding times. Having to go back to the initial seller, trying to track that documentation down, and sometimes it's just not out there, which creates a lot of difficulties for us here in Ohio.
All right, I'm gonna let Matt jump in here. Kathy expanded her question. Kathy, try putting it to everyone as well. But she really wants to know, how do you know you're wiring to a reputable seller? They'll give you the collateral file. No purchasers don't give you their source they're buying from because they don't want the competition. Kathy, I believe you're going through more of a broker situation where we're looking to buy direct. Places like Condor and Bayview and all things like that, they're more direct people. If you're buying through somebody that's buying from somebody else, just be very careful with that because I would probably agree, everyone on the call knows there isn't a lot of people in the space. It's not about finding a new deal, a new seller. It's actually finding the deal inside the seller we know about. There's not a lot of sellers selling to our level. So if you're buying through somebody who's buying through someone else, just avoid that. Reach out to us directly. There's a lot of inventory out there that are from some of the bigger hedge funds that are enough for everybody. So I would really focus on that. So Direct Source, she mentioned Direct Source. Direct Source did a lot of contract for deeds. They are a broker for CFDs in Ohio and whatnot. Matt, did you want to add anything to that as well?
Quite a bit. To be clear, I don't mind doing a deal with the devil as long as I know the rules. There's a few people that I've shaken their hands and I have to count my fingers afterwards. But within this space, there's a lot of reputable individuals whom I have deep respect for. However, regardless of some people that I may call friends personally, business is business and friends are friends. One is protected by what's called a purchase and sale agreement. As I expect homeowners to understand and read the contracts that are provided to them, I read the contracts that are provided to me, especially during a purchase where I am purchasing traditionally hundreds of loans and spending a considerable amount of money doing so as well. So in the event that the seller does not fulfill their end of the contract as a creditor, I will treat them the same way I treat a borrower. I will enforce the terms of that contract by whether it be sending a demand, contacting them, and going through the processes and procedures. And I found that there are certain sellers, to be very, very honest and blunt, that it traditionally respond only when they're shown an orange jumpsuit. So they traditionally settle early and quickly. Similar to notes, is that I'm a big fan of notes where the foreclosure timeline is short and it's inexpensive. However, I do own notes nationwide, and I will preface that a good note is a good note. While it may take longer to foreclose and acquire title in certain states, in the event it's a good note and there's equity within a property, homeowners are traditionally incentivized to settle these early and often. So they will traditionally respond to some demand letters or the onset of a foreclosure process rather than in the later stages. But that's something that can certainly be accounted for early on. In regards to seeing all the collateral, again, I traditionally purchase hundreds of notes at a time. And when this happens, not all the assignments are there. Not always the allonges are there. Sometimes certain documents are missing. A lot of this is resolved within the judicial foreclosure process. But the other thing that can take place is that in the event it is possible to go non-judicial, there's, of course, lost assignment affidavits, lost note affidavits, but outside of that as well, which those cause some issues with title later on or may cause issues, is it's possible to get something referenced as declaratory or declaratory relief, in where the court issues an order that regardless of the missing document, that one is still the current beneficiary in possession of the note, all legal documents and rights and remedies afforded thereunder.
Wonderful. Awesome. I'm going to close up with one last question that I've used before. Will you guys hold a file for filing for foreclosure in office? And will you review our documents and ensure that the documents are all there? Or do we need to use a collateral management service if it's something that's in the foreclosure process? Harris, I'll let you guys go start off.
Sure, thank you. I have no problem holding the collateral in my office and signing a Bailey letter that we are in fact in possession of the original collateral. So I don't have any problem with that, whether that's pre-litigation or during the litigation. One thing that you said that struck something in my mind is before we actually do anything with the litigation, even sending a default letter, we review that collateral to make sure that the party that we're representing actually has the standing to enforce the loan. So just because you have a note but what you don't have the proper endorsements, we still need to do some work before we can actually send a demand letter or file a lawsuit. I know I got off track a little bit, but it's important to have good collateral. If you don't have good collateral, you're creating FDCPA and FCCPA violations for yourself.
Yeah, there was a question in chat about from Karen that should buyers require seller to show allonges and assignments in PDF before buying? My answer is yes. They should be able to send us the entire electronic file. If I'm not buying with one of my common attorneys, I send it to a collateral management file company to review to make sure I'm not missing any issues, signatures, or whatnot. Tom, about holding a collateral file and reviewing it.
Yeah, I typically, I mean, in a specific circumstance, we might be willing to hold a collateral file. We really have very little reason to have original documents in what we do. So I would prefer not to, hold documents unless they're needed for a specific purpose. I mean, our firm doesn't want to be a repository for collateral documents, I guess. That's where we'd be. What was the second half of that question? I'm sorry.
The question was,
Tom, do you not need the original collateral to present to the court at a final hearing?
Are you asking? We don't have, typically no. I mean, if the question is, are we required to show original documents at a hearing? Typically no. Copies are going to be acceptable through the entire process, unless for some reason a document has come into question as to its authenticity, forged signature, that sort of thing. Then we'd be required to exhibit an original. We're able to do most everything via an affidavit to have the holder certify that they've been in continuous possession of the note, since the foreclosure was started and those sorts of things. So it sounds like we're pretty fortunate maybe here in Ohio.
Yeah, that's not true in Florida. In Florida, we have to present the original note at the final hearing in order to get a judgment. Or a lost note affidavit. But if we have the original note, that original needs to be presented to the judge, and it's canceled and filed with the court when a judgment's entered.
Yeah. We don't have that. So.
Awesome. So I do want to jumping in real quick. I'm gonna let Matt go ahead. Matt, you can speak.
Let's see.
I
generally agree with them. But what's the main question? Because we got off on a lot of different tracks.
I was making sure some people are calling in via phone. So in the chat message, can you just let everyone know what you described in the chat?
What I described in the chat is there was a question as to requiring selling to show allonges, assignments, any other documents before buying. I said, no, it's not I don't traditionally require sellers to show everything, but it's really not a bad idea, especially on one-off purchases. It's something to consider when certainly determining the purchase price or what I'm willing to bid on a note. With less information provided, quite honestly, the lower I'm going to bid. With the more transparency and the more information afforded to me, well, that's something that I'm willing to pay more for. And it's common for provisions to be in place within the purchase and sale agreement stating that one will get all needed assignments and allonges. But then again, I've had that provision and I've purchased from certain sellers and have had to enforce those provisions, which cost time and money. So it's something to look into. As to receiving the original collateral as a foreclosure trustee, we don't require it. It's not needed. I understand how some people are constantly afraid that their house is going to burn down, so they're not comfortable keeping it in a box or a filing cabinet within their own house. But personally, there's really no need on my end to have somebody stick it in a filing cabinet. I'm pretty good at that.
Wonderful. Thank you very much. If there's any more questions, we're going to kind of finish up in a second. I want to thank everyone for joining us tonight, as well as the attorneys. It seems like everything's been answered If there's additional questions, please put in the chat. I'm going to post a quick poll, and then we're going to go ahead and I'm going to put your contact information again back on the screen. Give me 1 second. We're going to launch one more poll, and then I'm going to put your information. It's just about what next we want to be talking about next month. Again, I'm going to stress the fact that we may not go next month immediately. We may take a month just to kind of recoup and deal with the summertime. I do appreciate So the poll is up. Please just answer the question in there. And then in a few minutes, I will go ahead and get more into their contact information. Any warning, last words at all for everyone? Any additional things you want to add to this before we end up? Harris, any kind of final words? Again, tell about yourself and how they can reach you.
Yep. Well, thank you very much for everyone participating in the chat. I think it was certainly beneficial. I learned a little bit about some of the processes in the other states. Anytime anyone has any questions, either during diligence or after they purchase a loan in Florida, I'm happy to help, even if it's just to ask a question or if it's to handle 100 mortgage foreclosure litigation files. We can certainly help, and I think David can share our contact information. Again, my name is Harris Howard. We handle mortgage foreclosure litigation, REO closings, and bankruptcy work throughout the state of Florida.
Thank you very, very much. Thomas, go ahead and your final words.
Yeah, I'd just like to thank everybody for having me tonight, Dave for inviting me, and you can learn more about me and our firm at www.walker, W-A-L-K-E-R, Novack, N-O-V-A-C-K.com. Or you can feel free to call me at 614-423-8276. I'm at extension 103. Be more than happy to talk. You know, if you got a general question or a quick question, be more than happy to pay it forward if you have any issues in Ohio, Michigan, or Kentucky.
Well, awesome. Thank you very much. Matt, anything final from you as well?
Always happy to help out. Feel free to contact me at any time. Dave does have all my contact information and the authorization to release that. So we're here to help out. And that's either providing your opinion as a foreclosure trustee, or I'm happy to provide my information as, again, I believe in what we do. So I do own notes personally and can provide that perspective as well.
Awesome. Great, guys. I'm posting your information on our big board here as well. Again, thank you everyone for joining us. We will be in touch. If you have any additional questions, feel free to reach out to me directly. Dave Putz, JKP Holdings. My email address is dputz@jkpholdings.com. And I'm getting a sign from my school here that we should make this a little bit larger. So I apologize. There we go. That better? Right. Yeah, I can send it. If anyone wants information, shoot me an email, and I will get the information right over to you and post it on on my Facebook page, the business page as well. Again, thank you so much, everyone, and have a good evening.
Thank you.
Thank you very much. You as well.
Take care.